Final. Check it me. We'll take up, there are 4-5 more motions. We'll take up that and then come to your case.
Registration was required to be filed as files. Along with all the requisite documents. You have to put in the process of conducting for any bulky record of appointment of over 11,000 candidates. Find three, 20 file that registration. In fact, I have just kind of copied by the commissioner as well. And we are required to, and we also had, on the last day that a common to be filed, but we got a copy from them, we are required to.
We are also doing it at our end. Just some more time. No, as far as tabular, as far as I'm concerned, Lord, it should be sanctioned. Therefore, for that tabular that we are making, because it's involved in the production done a lot of. Therefore, we wanted to be pitch perfect about it.
Can we dispose of all these cases and say that the judgment of the Supreme Court will be followed? That's all. You follow the Supreme Court judgment.
First,
We have not adjudicated anything. So you read it, understand it, and implement it. If somebody has a problem, will come to the court.
My lord, first, my lord, will be done. Idea number 528. We start the last state of hearing, no reply has come. In that, Lord, has said that K.C. Nandan, Lord, and Rohit Chaudhary, both of them, my lord, have got appointment. So as far as their petition is concerned, that can be dismissed as having become infructuous. Because that is it. Because service matter PIL is not maintainable. And this is not a quo warranto, nor is this the scope of quo warranto. But quo warranto is right after the appointment. My learned friends also know it very well. So Lord K.C. Nandan may be dismissed because I have not received reply to 5284. My lord was appreciating that argument of mine in the last case of hearing, I remember, that there are only two petitioners in K.C. Nandan Sahu, and both of them have got appointment. Nothing remains with this petition. This petition may kindly be dismissed.
Lords, I appear for the petitioners in Kesari Nandan. If your lordships can just hear us for a minute. After the Supreme Court's order, which has been passed, which is dealing with the substance of, I'm sorry.
B.Ed order, B.Ed not interveners in K.C. Nandan Sahu. So, Lord, I was saying, as far as K.C. Nandan Sahu is concerned, because PIL is not maintainable, Lord, in service matters. And this is not a case of quo warranto, nor is the scope of quo warranto like this, my lord and my learned friends are well aware. All of us are practicing on service matter side. So, therefore, only thing is that K.C. Nandan will have to be dismissed, provided you file a reply to 528. No reply.
We'll deal with that again later on.
Let that.
But there is a request made by the state that
Yes.
there is more time for filing that table. Now, the suggestion of the court to the state is that since there is no question of any adjudication, because that has been done by the Supreme Court. So we will say that the state should follow the Supreme Court judgment.
That's
I am
fine.
for the selected candidates, my lord. We are all right with that. Let the state take a call. And because according to us, we are covered by that order completely.
Lords, that will have another round of litigation then, clearly from the positioning that is being taken. Because I can show to my lords that my lords have passed at least 3 interim orders saying that all appointments will be subject to the outcome of the final in the writ petition. Now, the Supreme Court's order, which has been passed,
Is it doubtful?
I beg your pardon, my lords, I couldn't hear.
Either you say it's ambiguous,
No,
it's not clear.
My lord, is absolutely crystal clear. It's only if the person who is appointed had filed a petition and got an interim order.
That is
he
not said.
Will not be, he will not
I
be
think
affected.
Mr. Patwale has
Otherwise, he will be
misunderstood
clearly
the order.
protected, my lord.
Completely.
That's
That
the whole
is-
intention
Best
of the
thing is to
order.
read the order, my lords.
Yes.
There are
My lords,
only 2 conditions that are required. The first condition is that the person should have been appointed, a B.Ed candidate should have been appointed prior to the date of the Supreme Court's judgment. The second condition, if that B.Ed candidate wants to continue to have the protection, that B.Ed candidate should not have had his appointment made subject to any order of a court. In our case, as far as Madhya Pradesh is concerned, after the advertisements came, challenges were brought before this court, including in Kesri Nandan's case. Your lordships passed not one but two interim orders. The minute those interim orders were passed, the guillotine has fallen on all B.Ed candidates who wanted to take advantage of the NCTE notification.
That's a
That's all the
misreading of the order.
interpretation is.
The order
So
is very clear.
if we can
It
show your
says would be
lordships
subject
the
to final
order. We have
outcome.
filed a
It
compilation.
might have been
Mr.
instituted by
Patwale is
them.
for an intervener. I'm sorry. Can you allow me to complete? I'm the petitioner in the first lead matter. We have others have also intervened. Let me just argue on behalf of the petitioner. We have filed a small compilation, my lords, to put everything in one place to make it clear and simple. If your lordships can just take that.
Is it the court?
We have to take it back to the department. and-
Yes, we have placed it before the court.
There are 1,000 people, maybe 10,000 people. So how many will come back? Not more than 5%.
No, we don't know.
Absolutely right, Munot. Let the
That's
state
11,000.
take a call as to what is
It will
to be
get
done.
opened up all over
affidavit,
again. The
1
idea behind
minute
the
miss-
Supreme Court reviewing its own judgment and giving a final judgment was to ensure that nothing more will trickle up, my lords. I'm just suggesting your lordship may see your orders and the advertisements. That will put everything in the clear.
My lords, as per the state government in its affidavit filed before the Supreme Court, the dates of appointment are crystal clear. Those dates happen after the orders passed by my lords, including there was an impleadment filed by these candidates before the Supreme Court, and Supreme Court had itself in an order said that the all appointments or whatever in the pending proceedings will be subject to the outcome. So not only was this court, but there was also the Honorable Supreme Court's interim order there.
Can we just show you the Supreme Court's order, my lords? It's April. That's the only thing of which an interpretation is sought now.
Kesri Nandan and Rohit Chaudhary.
No,
So
we-
that petition should go, but why they are opposing, I fail to understand.
So, Rupra, we are dealing with the real issue. Your issue is not so real as the issue of, let us say, and let us take out the Supreme Court judgment and take out points, because we were hoping and expecting the state to assist us. But the state seems to be,
Therefore, we opened by submitting that on 15th of.
because there is no adjournment, no adjudication left now. There's no adjudication.
The state has to come out with a stand as to what they are doing, and ultimately whoever is aggrieved can have redress against that.
Parties are directed to find a common standard.
My lords, if you take up the compilation which we have filed on behalf of the petitioner,
And therefore, that.
Only to assist the court. Now if the court does not need your assistance, you prevent the court from going ahead.
I'm only
So-
teaching this honorable court.
Because the entire adjudication has been done by the Supreme Court.
Absolutely right.
Do that.
Absolutely.
We don't have to indulge into that.
It's almost ready. We have received from my.
there's no reason for the state to continue delaying like this, my lords.
That's fine. We'll deal with that as per we'll say that state government should implement the Supreme Court judgment.
But can we just drop one interpretation because rather than open it up in future, my
Make
lords,
that clear. That is why I am repeatedly emphasizing my idea 528. Supreme Court judgment deserves to be implemented.
My lords, may I make a submission here, if my lords may permit me?
Deserves to be
My
implemented
lords.
in respect of Vipin Kumar Dwivedi and all those advocates, my lord, who are representing the petitioner in Kesri Nandan have no right to address this court because nothing remains in their case.
So let us take up the Supreme Court.
Yes.
Let us take.
it's at page 20 of our compilation, my lords. In Kesri Nandan, in the lead matter, we have filed a compilation
24.
No,
at page 20 of which
let them demonstrate.
is order of 8th April 2024.
Mr. Rupra,
Wait,
we'll take up your case later. First, we'll take up the main issue.
the main issue, my lord, is in Vipin Kumar Dwivedi. K.C. Nandan can apply.
Wherever is that Supreme Court judgment? Where is
Yes,
that?
Lord.
It's a
Where is
page
Vipin Kumar
20 of
Manoj, it
our
is there.
compilation.
That is the main judgment. KC Nandan is some PIL, which is not even maintainable, my lord.
Manoj, we have filed a
think-
compilation in the lead matter in item 24, in which at page 20 is the order. It's order with April 2024.
In the first week of May, let it be heard finally, commencing from first of
I
May.
think we had sought your assistance. The court does not need your assistance and our adjudication process is over by the Supreme Court. Now it is only that we have to just point out that what has to be done. That's how it is to be implemented. That is all.
Exactly, Manoj. That's all that needs to be done.
It will be general, it will be a generic kind of an order, direction that if this happens, please do this. If this happens, please do this. If this is the eventuality, do this. Otherwise,
That's right, Manoj.
it is covered by the Supreme. Who goes out and who remains in service and who gets out. That is all to be identified. That's all.
It's an important issue.
Yes, sir.
There is a writ petition in the bulk. The petitioners are appointed already. How can they maintain the writ petition? There are so many issues which are to be addressed before the Honorable High Court.
That we'll deal separately. We'll deal separately that Mr. Rupra's objection. We'll deal that separately.
So therefore, my lord,
Would your lordships have the court's order, Supreme Court's order?
under the comment, we have already almost prepared it. But I don't know why my member friends are objecting to it. I don't know if this matter is posted the first week of May. Let it be heard on any day. We commencing from 1st of May.
My lords, if we may see the history of this matter and the number of times the state has asked for an adjournment, on the contrary, in the last proceedings, my lords, this comment that the state is deliberately taking a position which it should not be.
Because she is in K.C. Nandan.
If-
But please, first beat out these cases, Lord. One is K.C. Nandan. the other-
Let's not get into locus standi now. There's a Supreme Court order at your behest.
A
at the
PIL
state's
has to be
behest.
rejected at the outset, my lord.
The
A
state
PIL
of
can't
Madhya
be
Pradesh has
maintained.
gone to the Supreme Court and got an order. That order has to be implemented. We need to just see that order now.
Either you say that PIL is maintainable service matter, show me some Supreme Court ruling. So,
May
Lord,
I say this, my lords, let's put a quietus to this. There is Kesri Nandan and there is Vipin Kumar Dwivedi. There are two matters before my lords and they both are available for my lords for
I don't
consideration.
know why my friend keeps saying it's a public interest litigation. If he at least reads the papers of that writ petition, you will see it is a writ petition on behalf of DI-led candidates. I don't know why it suddenly become a public interest litigation.
because
This is obviously just a scheme to try and interrupt us when we are placing the order before the court.
It says, I read that the instant petition was filed challenging these notifications, whereby candidates possessing B.Ed were made eligible for post of primary school teachers. Petitioners also participated in the same process, holding the degree of DL.Ed. For the
Precisely why it's not a public interest litigation.
post of primary school teachers in the same selection process, which they are challenging. The name of petitioner number
So it became a
one
public interest.
dated 4/4/2023 of District Anupur at serial number 225, that is filed here as an action IA1. The name of petitioner number 2, Rohit Chaudhary, is mentioned at serial number 25 of select list dated 4/4/23, 4/4 IA number 2. Both the petitioners have joined on the basis of the said orders dated 4/4/23, IA1 and IA2, and are working in District Anupur and District Dhar respectively as primary school teachers since last about 1 year. Their employee ID has also been created.
My lords, may I make a submission to cut this short? There are two matters before my lords. Vipin Kumar Dwivedi and Kesri Nandan, my lords may hear us and then hear them later on that.
No, but not
But,
without
this-
they have no right to address the court.
I can't understand. That's for my lords to decide later on after we have put up a case.
Or the BA candidates go out of the court or not? How Lord Kesri Nandan or Rohit Chaudhary is going to be affected? That is a good question.
In fact,
Kesri Nandan can argue Vipin Kumar Dwivedi are prepared to argue right now, but no counsel should buttress the case of KC Nandan and Rohit Chaudhary.
I will. I fully insist that I will.
First, kindly address on locus. Who are you?
Because Mr. Luthra should clarify whom is he appearing for. His intervention till date is not been allowed. Who is he? He's not a respondent in my matter. How can an intervener whose intervention is not allowed have the first audience at all?
It's allowed, intervention is allowed, that was allowed long back. And right from the beginning, we have been insisting that this KC Nandan has been rendered infructuous because both the petitioners, they already have been appointed. And having participated in the same process of.
All right, we are resolving the cases and we'll try to decide the cases. If it's difficult for us, then we'll release.
My lords, as the petitioner in the first matter, can I have 2 minutes?
If certain facts are evident from the pleadings, I think it should be evident from pleadings.
My lords,
That's
and
what-
in that Vipin Kumar Dwivedi, can I point out three
Can we
orders?
make just 2 minutes of submissions on behalf of the petitioner? Just 2 minutes, that's all. It will not take more than 120 seconds.
Class of.
Yes, Manoj. It's simply this. If you look at the order of the Supreme Court, there are very clearly it states, your lordships have seen the order, then I'm not going to trouble your lordships with it. But I'm just reading out 2 sentences from it, which is the relevant portion of it. It says that before us, 2 sets of parties are there. One set wants retention of the said judgment in its present form. The opposing side alleges that it would result in loss of employment to those who were already appointed as teachers in different states on the strength of their B.Ed degree. This B.Ed qualification was what was struck down by the Supreme Court. It is submitted that they had entered their employment following a legitimate course as per notification issued by respective appointing authorities,
Where
which
are you
did
reading?
not
Where are you reading in the order?
This is in the Supreme Court's order, page 5 of the Supreme Court's order, my lords.
Okay.
It's page 24 of the compilation, if you have the compilation.
Yes.
It's at page 4. It's the bottom paragraph at page 4.
Yes.
So it makes it clear who the 2 sets are, my lords. One who wants retention, the other who are those who have been appointed as with B.Ed qualification who don't want to be thrown out. That's the 2 sets. Now, after having considered all of this, if your lordships will come to the bottom of page 7, which is 26 of the compilation, bottom of page 7.
Yes.
As it appears that a large number of candidates with B.Ed degree had already been appointed on the basis of eligibility criteria specified by the educational authorities, we do not think it be equitable to effect their removal. We accordingly hold that the judgment delivered by this bench on 11th August 23 shall have prospective operation. But, and this is what we are relying on, prospective operation of this judgment shall be only for those candidates who were appointed without any qualification or conditions imposed by any court of law, to the effect that their appointment would be subject to final outcome of the case, which might have had been instituted by them, and such candidates were in regular employment without any disqualification and were appointed in pursuance of a notice of advertisement. This is the second condition. Appointed pursuant to notice of advertisement where B.Ed was stipulated to be valid qualification.
Yes.
Services of only such candidates shall not be disturbed because of this judgment. We make it clear that this benefit is only for the candidates who were appointed. Please note, my lords, appointed prior to the date our judgment was delivered, that is on 11th August 2023. Mere selection of such candidates or their participation in the process will not entitle them for a benefit under our present order. I'll just give your lordships the relevant dates, my lords. The first advertisement that was issued was on 6th January 2020, after which we filed our writ petitions, my lords, in which, and this is why the locus point keeps coming up, we asked for not only the striking down of the NCTE notification, but also that B.Ed candidates not be made eligible. Even in the future, if they are allowed to take part, it would affect us. The High Court passed interim orders dated. Please note these dates, Molo. This is relevant because both these dates are before the Supreme Court's order. 7th July 22, your lordships passed an interim order. 7/7/22.
My learned friend is not here. Here, I expect to never want to.
Pursuant to which some of these people went and intervened in the Supreme Court.
Does not survive, Lord. why my learned friend is not addressing on locus law?
After
Lord,
7th
after
July
he finishes,
22,
after he finishes,
surely
I
I
want to
can
respond to what
complete
is
what
being
I'm
argued.
saying, Manoj. Surely I can complete what I'm saying.
Now,
The
whether
first
it's
interim
clear
order
or
is 7th July 22.
that is
The
not
second interim order is 16th January 23.
Kindly appreciate, Madam. Yes.
7th July 22 and 16th January 2023. The order of the Supreme Court, the judgment of the Supreme Court, which is the cutoff date, is 11th August 2023.
Very first occasion, Madam.
Of our friends who have been appointed, I'm sorry,
Learned friend is taking your ownership to the judgment of the Honorable Supreme Court. Now, we are not quarreling on the issue that some judgment is pronounced by the Honorable Supreme Court,
Yes.
and it has to be implemented. There is no quarrel on this issue. But then the point is,
just
maintain
Can I
the how to address the Honorable
Lord,
Court on this issue.
may I respond on the judgment of the Supreme Court?
I was just completing, Manoj. I'll just take half a minute to complete now.
He's arguing in which case?
These are the-
My lords,
I'll just take half a minute to complete, Manoj. We had the same problem in the Supreme Court because people who are anxious to protect their jobs are obviously very anxious. I can understand that. I'm just stating the facts now.
Your clients, Mr. Shankar Narayanan,
Yes, Manoj.
are diploma holders.
yes, my
Yes,
lords,
we are
both are
DLED
clients.
holders. We are the only ones eligible for
They
these
have
posts.
been appointed. They have been appointed.
They've now been appointed. Now, yes.
All right, so,
No.
so they will not be adversely affected by the Supreme Court. judgment.
The B.Ed candidates who are senior to me, they are the ones who are going to affect me. All of them have to be out. If they, as per the Supreme Court's order, if they did not have the protection of an interim order,
Yes.
then it's a different matter. Here there was interim orders which protected us, all of us as petitioners, and said that it would be subject to outcome. And those interim orders were passed prior to the cutoff date, which is 11th August 23. Two interim orders were passed. And Manoj, the Supreme Court has said you must look at the dates of appointment.
That is evident from the
Lord,
record.
if I may now, if my friends 2 minutes are
Yes,
over, if I
we
may
are drawing
respond.
your lordship's attention to two
Before-
facts. One, the dates of the interim
Lord,
orders.
this is what they did in
Two,
the
the
Supreme Court.
dates
They didn't
of
allow the other
actual
side to argue.
appointment.
We
dates
go
of
through that,
actual
we
appointment.
go through the record, Mr. Shankar.
Lord, may I just have
Very well,
2 minutes?
then I won't
May
say
just
anything
have
further.
2 minutes
My
from
lords,
from the
can
other
I,
side?
before
Lord?
Mr.
Now,
Patwalia starts,
before
I
the
am for the
Supreme, just 1
petitioner.
minute, 1
Mr.
minute.
Patwalia,
You
I
are
am for
both
the
on the same
petitioner.
side. Please let me present the other picture.
My lords, can I appear for the petitioner and then Mr. Patwalia can argue?
Lord, they are both on the same side. So
My
let
lords,
me
that's
present
not the
the other
case. I
picture now
appear
that
in
one side
another
has been
matter and I
presented.
want to point different facts. Please do not do that, Mr. Patwalia. I appear in a different matter with different
This is
facts.
what happens.
You
Anyway, I'll
did
wait,
the
Lord.
same thing in the Supreme Court, not
I'll
allowing
wait.
anyone to argue. Please,
I'll
don't
wait.
repeat it now.
Yes.
My lords, I'm going to be very short and crisp. I won't take longer than at
How
least a couple of minutes. Now, my lords, can I just say one thing? The crux of the matter is the Supreme Court says the appointment had to be without any disqualification. The submission that we make before my lords is that in the writ petitions that were filed way before.
Lord,
Yeah,
I
resolving-
have to make a point. Lord, I have to make a
Yeah.
point. I'm on the other side.
Say that
My
there-
point is this, Lord.
My lords,
If
there are
it is
four
in fact-
interim orders. There are
Lord,
four interim
Lord,
orders.
let me make my point. Lord, that's what they want, that they should argue, other side should not argue, matter should be reserved. Now, the other side is, before the Supreme Court, there were two kinds of B.Ed candidates. One B.Ed candidate was where the candidate himself had gone to the Supreme Court because the state had declared him ineligible. Now, the other were where the state was declaring them eligible under the notification.
Find for BA candidates. No, we have not filed any petition by them. That is the
Yes,
order.
yes,
We are going to-
I agree with my learned friend. Just kindly read one line of the Supreme Court order, my lord, which appears at internal page 8 of the Supreme Court order. Can your lordship take the bottom of the Supreme Court order from page 7? Just kindly have page 7 at the bottom. I'll read that paragraph. As it appears, your lordship has got that, my lord, as it appears.
Yes.
As it appears that a large number of candidates with B.Ed degrees had already been appointed on the basis of eligibility criteria specified by the educational authorities, we do not think it would be equitable to effect their removal. We accordingly hold that the judgment delivered by this bench shall have prospective operation, but prospective operation of this judgment shall only be for those candidates who were appointed without any qualification or condition imposed by any court of law to the effect that their appointment would be subject to final outcome of the case, which might have been instituted by them. Why? Because Rajasthan had declared B.Ed ineligible. In Rajasthan, the B.Ed candidate had gone to the court and wanted to appear. The B.Ed candidate appeared provisionally under orders of the court, even though he was not eligible as per the Rajasthan advertisement. Then he lost, and therefore he is ineligible. A similar position happened in Chhattisgarh. Chhattisgarh decided against the B.Ed candidate. There, the B.Ed candidate went to the Supreme Court and he appeared subject to result of the Supreme Court. So it is only where a B.Ed candidate had instituted a litigation and appeared on the basis of that interim order that he is not to get the benefit. Here are cases where we are people who are eligible under the state rule. The rule still holds valid up to today. We have been appointed.
Sorry, this is
Our
completely
appointment order
preposterous.
does not contain any condition that it is subject to anything. We have an absolute appointment letter in our favor. And the Supreme Court therefore says only if the B.Ed candidate has got some interim order and got appointment on the strength of that interim order, only then he is not to get the benefit of the judgment.
So,
That
my
is
lords,
the real
now may I
import.
respond
There
to
are-
this?
Just
Now
one
may
minute.
I
There
respond to
are,
this?
my lord, there are
My
three
lords-
parts of the, just 1 minute, Meenakshi. There are three parts. If your lordship will see page 5, the para in the lower half of the page, there are three places where the Supreme Court says, if you are appointed, we will protect you. That is the underlying order. If your lordship will see para 5, bottom of the page. Before us, two sets of parties are there. One set wants retention of the judgment in its present form. The opposing side alleges it would result in loss of employment to those who are already appointed
That
as
will
teachers
be-
in different states
My lords, may I
on the strength
respond?
of the B.Ed degree.
Yes, sir.
Then again, my lord, 6 at the top, see what the court says, page 6 at the top. Now, having considered these factors, particularly the contention of B.Ed applicants that they have entered into employment as per the qualifying criteria specified by the appointing authority, equity should go in their favor. This line is very crucial when we read it with page 7. Those candidates who have been appointed because they were qualified as per the criteria of the appointing authority have all been protected. It is only those candidates who were not qualified as per the state criteria and
Also
who secured
subject to-
interim
that is
orders.
also, Mr. Patwalia, I hope I'm pronouncing your name correctly.
Yes, absolutely, my lord. Absolutely, I'm
So,
grateful.
That is also subject to certain conditions mentioned at page 7.
Correct. So
Yes.
let us read it, my lord, because it was hotly contested.
We'll clarify that 1, 2, 3, 4. If this happens, retain them. If this happens, don't retain.
Yes, because then your lordship will have to read the first 4 lines of page 8 very carefully, because any court of law that their appointment would be subject to final outcome of the case, which might have been instituted by them.
Maloj,
If
in this
the other
case,
side's interpretation is
candidates from
accepted,
UPF
and
filed an
nobody is
application
saved.
in the Supreme
No,
Court.
this is not the object
Mr.
of the order.
Patwalia is not disclosing that.
The
On
object
11th of
of,
October 2022,
just please don't
the
talk over
candidates
me.
from
You will
UPF
have
filed an
time.
application in the
Allow me to
Supreme
finish.
Court.
Allow me to finish. Don't get anxious.
Sir, at least take the right
Now
facts.
the point is,
Mr. Patwalia, please finish.
yes. So, my lord, I am only saying, my lord, the underlying object of this order at 4 places is anybody who has secured appointment should be protected if he is qualified as per the state government regulation. It is only if you have secured an appointment when you are not qualified as per the state government's rules by securing an interim order that you are not protected, is my respectful submission.
My lords, may I
And
just
my
have
second
by the
respectful
clock,
submission is,
by the
if
clock,
this
my
interpretation
lords-
is not the correct one, then this order protects nobody. Then everybody goes, because everybody who is there was all subject to some writ or the other, and therefore this order
Yes, my
becomes
lords, let us now
completely odious.
let us look at what has transpired here. 1
And-
minute now,
and
Mr.
also,
Patwalia. I think
Calcutta High Court, in fact, has also passed an order.
Mr. Patwalia, let Ms. Arora also.
my lords,
make
just
One
few
last
minutes
line,
and
one
I'll be
last
very,
line.
very
The
quick with
Calcutta
this.
High Court has passed an order on 19th, and the Calcutta High Court has said exactly what your lordship said when the hearing opened, that Supreme Court has decided the state government is to take action strictly as per the Supreme Court order.
Please give us the
So,
copy.
my lords,
Mr. Siddharth Shukla will have the order, my lord. Mr. Shukla can pass on to your lordship
so,
that order.
so my lords, now where the state is
If your
making a
lordship, just one
submission
line,
and
one
Mr. Patwalia is saying that, I think there is a need on how my lords will pass this order. May I just show very, very quickly few pages, which I say is completely the Supreme Court order when it cannot be applied in respect of B.Ed candidates who have been appointed, where my Lord's direction to the state were already in place, that appointments, if any made, will be subject to the final outcome. The first order that my Lords passed was on 7th of July 2022. My Lords, the date is very important. My Lords will find this at page number 1 and 2 of my Lords compilation, to which Mr. Gopal Shankar Narayan was referring to. My Lords, on 7th July 2022, on this date, no appointments had been made, but if any appointment, I take it, had been made, will be protected by Supreme Court order, but after this, definitely not. My Lords, after this court passed an order on 7th July 2022, and the relevant parties, recruitments in question and any appointment made shall remain subject to final outcome of this petition. My Lords will find it at page number 2 of this particular compilation. Now, my Lords, what happens is that on 11th October 2022, B.Ed candidates file an application before the Supreme Court for intervention. The matter comes up on 12th October 2022. Yes, for impleadment. And my Lords, the matter comes up on 12th October 2022. The office report notes that this application was before the Supreme Court on that date. Please turn to page number 7 of this compilation and please see the order passed by the Supreme Court on 12th October 2022. And it says, my Lords, any steps taken during the pendency of these proceedings having impact on the controversy out of which these proceedings arise shall be subject to the final outcome or any further order that may be passed in this matter. Now, B.Ed candidates have approached through an impleadment, and this is an order that is passed by the Honorable Supreme Court. Now, my Lords, the first advertisement thereafter of the state comes on 19th October and 16th of November. And my Lords, another advertisement comes up on 26th of November. A writ petition is filed before the Madhya Pradesh High Court, and Madhya Pradesh High Court, by an order of 16th January 2023. All these orders are prior to these appointments. My Lords, please turn to page number 8 of the convenience. Now, please turn to page number 8. This is not now Kesari Nandan, this is in Vipin Kumar Dwivedi. In this petition, the court says, all further actions by respondents will be subject to further orders of this court. My Lords, the way Madhya Pradesh government has been going, my Lords should see, because there's a direction to them and they are aware that they can't make these appointments. Now, my Lords, what happens is that the appointments for the first note advertisement, which is 19th October 22 and 16 November 2022, happened between 30th of March 2023, which is after my Lord's order of 16 January 2023, till between 15th of April 2023. Would my Lords be so kind and turn to the affidavit filed by the state of Madhya Pradesh before the Supreme Court. My Lords will find this affidavit at page number 12, and the categorical statement made by state of MP is at page number 16.
All this has to be now going by the final
1
order.
minute now, Mr. Patwalia, you've had
It has
your
to
say.
follow all appointments
Yes,
which have been made
now,
on
can we,
petitions not filed by
Mr.
us.
Patwalia,
Will have to be
please
saved.
don't obfuscate the other side from presenting their case. You have said, please allow me now. Now, my Lords, this is an affidavit filed by state of MP. Please come to page number 16. And this is very, very important. It says, my Lords, in the second paragraph, first of all, there were total of 21,962 appointments, out of which 11,583 were given to the B.Ed. Now, what are the dates on which they have been given? Please look at the tabular chart below. 30th of March 2023, a total of 16,000, out of which 8,799 were B.Ed. 10th of August, my Lords, 1 day before the judgment. 1 day before the judgment, and I say this, my Lords, this is very unusual.
Who would know
Let
when
me
the
call it
judgment is
unusual.
coming? This
Yes.
is just
Lords,
creating
we
doubts
all
for
know.
nothing.
Mr. Patwalia, you've had your say. Please now rein your horses. Now, my Lords, on 10th of August 2023, 5,617 appointments, out of which 2,784 to B.Ed. Now, all these appointments are post orders of my Lords of 7th July 2022 and 16 January 2023, including the Supreme Court order of 12th of October 2022. My lords, I submit with complete humility when the court at page number 7 of its order, the Supreme Court, which my lord saw just now, at page number 27, bottom of page 26, 27, please read it now in that perspective. What has happened here? Once these orders had been passed, these appointments were all subject to the outcome. Today, the outcome is clear. The Honorable Supreme Court has held B.Ed is not an eligible qualification for the purpose of appointment to the post of primary teacher. The eligible qualification is D.Led. The only thing the court has said that if you had been appointed without any restriction or disqualification by any order of any court, my lords, that's page number 27. My lords just saw that. Only then you may be protected. Here, clearly, there was an order of my lords which put a disqualification that these appointments will be subject to the outcome of these petitions. My lords, the second thing that I most humbly submit to you is this. My lords, so far as the D.Led are concerned, for them, the only appointments can be for the primary school. So far as the B.Ed is concerned, the scope is much wider. And that is what has been noticed also by the court in Devesh Sharma. Now, if we are entitled to only these limited vacancies and have no other opportunities, while B.Ed have still a much larger area open to them for appointment, there is no reason why, my lords, those of us who are eligible, qualified, should not be given these appointments. And I most humbly submit that today, in view of the Devesh Sharma judgment of my lords 11th August 2023, and including this clarification, the present appointments which as per state have been made on 30th of March 2023 and 10th of August 2023 are in teeth of that particular order of the Honorable Supreme Court. And my lords, orders, the two orders that I've shown, 7 July, 16 January 2023, 7 July 2022, and Supreme Court interim order of 12th October 2023. My lords,
I can respond. It is, again, they have glossed over the words at page 8. They have been glossing over those words. Those words are crucial, that their appointment will be subject to final outcome of the case which might have been instituted by them. Supreme Court is crystal clear in saying so.
This is hair splitting, my lords.
Otherwise, Lord, nothing will be saved. Otherwise, this clarification is meaningless.
Mr. Patwalia, I think we have heard you.
All right, grateful. I'm sorry.
Otherwise, this process is going to become unending.
I'm sorry.
If every lawyer is going to respond to every sentence.
I'm sorry. I'm sorry.
So,
well, on facts, can I just take 10 seconds? Just 10 seconds only on facts, not more than 10 seconds.
He's assisting her first.
Just 1 second, sir. The Honorable Uttarakhand High Court has followed the same retrospective application, and the Supreme Court dismissed the SLP, saying that whoever has been appointed post the interim order has to be out. Recently, the Honorable Supreme Court on 5th April 2024 has dismissed the SLP filed by the B.Ed candidates. That's number 1. Where the Uttarakhand
that was before the clarification.
1 second,
please
sir.
tell them
Sir,
that is before the clarification.
If you don't mind, sir, please, if you don't mind, please. The Honorable Uttarakhand High Court has followed retrospective application wherein interim order, any appointment post that, out. Number 2, my lords, the Honorable Chhattisgarh High Court has again followed the same principle of law, where they say that any appointment post an interim order will not succeed in case they have been appointed post that interim order. So when multiple high courts have been following, and if my lords would want, we'll put that in a written submissions, not more than 5 pages, we'll put all of that, and how all the high courts across the country have thrown all the B.Ed candidates out where they have been appointed subject to an interim order passed by the Honorable respective High Court. That's all.
In those cases, I am told applications are being filed for recall because of this clarification. Those are all prior to clarification.
Today, there is no recall.
I hope the council appearing virtually have concluded.
Yes, yes.
We are grateful, Mr.
We are extremely grateful.
File a written
Very
submission
kind.
to be given, Mr.
We will get a chance. We are very sure after all these people come to the verbal hearing, and also like to address because of them have not. Let them address, Lord, we are silent. After that, my learned advocate general is also there. After that, हम लोग को chance देंगे.
Yes.
Yes.
Lords, please see. Admittedly, the advertisement was issued on The first advertisement which was issued.
I think the learned advocate general has the right to
Yes,
first audience. First
Yes.
audience, yes.
That is.
Firstly, your lordship can kindly see, there are uh, 5 writ petitions in which it said whether the interim order was passed. So, your lordship can kindly see WP number 13768 of 2020.
There was an interim order, yes,
The interim order was passed on 7th of July 2020.
yes.
Now we are raising serious objection with regard to maintainability of this writ petition. Because the petitioner willing, they have already been selected and appointed. Now, this writ petition has rendered infructuous. Now, the second writ petition is WP 595 of 2023.
Yes.
In this matter, my lord, the judgment from Honorable Supreme Court came on 11th of August 2023.
No, there was IR in this case.
IR was passed on 28th of August 2023. Subsequent to the order passed by the Honorable Supreme Court.
IR is dated is.
Bharat Kindly, WP 595 of 2023, Vipin Kumar Dwivedi.
28/8/23.
Yes, and the order of the Honorable Supreme Court is dated 11th of August 2020.
Yes.
So here, while the appointments are not going to be disturbed in this writ petition, the another writ petition is WP number 21800 of 2020. Tarun Agarwal. Now, in this matter, interim order was passed on 14th of September 2023.
Yes.
Similarly, in WP number 2218 of 2023, the interim order passed by your lordship on 21st of September 2023.
Yes.
And then finally, in WP number 29809 of 2023, Vivek Pandey. Now, in this matter, the interim order was passed on 15th of December 2020.
December 23.
Yes, yes.
Hmm.
Now, my respectful submission is,
Yes.
in the light of the judgment pronounced by Honorable Supreme Court and the condition imposed herein, the appointee in WP number 595, WP number 21800, WP number 2218, and 29809, they are not going to be disturbed. There is no appointment order will be disturbed, madam, if we implement the directions of the Honorable Supreme Court, because it has been given prospective operation, madam, and prior to passing of the judgment by the Honorable Supreme Court, there was no interim order passed by your lordship, my lord. Now, there is only one writ petition which is left. Is Kesari Nandan Sahu's matter now. And in that writ petition,
Yes.
the appointment has already been granted to the petitioner.
Yes.
So they came before your lordship. Then they could not take up the selection process. Because they have raised grievance with regard to the selection process undertaken by the candidates and the initiated by the state government. And subsequently, these petitioners, they are appointed. Now, we are, my learned friend Mr. Rupa and my learned friend Mr. Gindia, but all they are raising, interveners are raising objections that they cannot maintain their petition. Now, the issue to be taken into consideration before your lordship is, once the writ petition goes on this objection that it is not maintainable, but the interim order which was passed on 7th of July 2022 in that writ petition would also pass in the final order. Therefore, my lord, we have raised this objection, and that objection needs to be addressed. Now, while learned friends who are appearing in that matter, instead of addressing your lordship and assisting your lordship on this material issue, they are taking your lordship to the judgment pronounced by the Honorable Supreme Court. But even we are saying, the judgment which is passed by the Honorable Supreme Court, that has to be implemented. Yes,
And what about the remaining cases?
no, in the remaining matters, there are in most of the cases, notices are also not even issued. And no interim order is there.
That is 24.5 to 24.10.
सब कुछ में in few matters notices are not. No, in fact, the notices are also not issued in these matters. In 5-6 rectifications. So, what I am respectfully submitting your lordship may kindly appreciate. The interim order which was passed.
So in 24.5, there is no interim. Then 24. Now let us see 24.6.
Your lordship may kindly appreciate. I have referred the number of writ petitions. There are only 5 writ petitions in which the interim order was passed by your lordship. Out of which there are 4 writ petitions in which interim order was passed subsequent to the pronouncement of judgment by the Supreme Court.
Yes.
Now, in one of the matters, Kesri Nandan Sahu, in that particular, the interim order was passed on 7th of July 2022. That is much before the judgment date of pronouncement of judgment by the Supreme Court. And in that matter, we have raised this objection that writ petition is not maintained. The petitioners are appointed. They have no grievance. And they maintain their writ petition before your lordship. Therefore, one of these need to address of this material issue. How they have now submitted that there are several appointees who are having qualification of BA. Now, whether it is pleaded in the writ petition, whether they have raised any grievance with respect to this category of candidates who have taken up the selection process and ultimately appointed by the state. So all these things are required to be seen, and therefore, the objection which we have raised to go to the roots of the matter, they cannot maintain that writ petition, and therefore, I am making a more humble submission that this objection which we have raised, many friends have raised, they are required to address and assist your lordship on this issue. And once your lordship is satisfied, yes, then their writ petition, then whatever direction which your lordship will pass, will bow down to it.
That is the first case.
And those maybe respond.
Only in the case of inquiry number south.
No, my lords, also Vipin, also in the case of Vipin Kumar Dwivedi, order was passed on 16th of January 2023. The prayers made in all these petitions are broad and wide, in fact, asking that B.Ed are not qualified at all. And my lord said that appointments, if any, will be subject to further orders of this court. It is at page number 8 of that compilation. That is 16th January 2023. The prayers are wide and they are across board, my lords. So it can't be said that it applies only to the petitioners therein and not to other people who will be affected by it. I don't think that may be a right submission at all to make in matters of this nature, where there is a challenge to that very policy, the qualification itself, which has been struck down. And we cannot lose sight of the fact that by this time, Rajasthan High Court had actually struck down that qualification of B.Ed. The judgment of Rajasthan High Court pronouncing it in rem was already there. And be that as it may, nevertheless, if the state of Madhya Pradesh took a position, appointed people, cognizant of the fact that B.Ed is not a qualification struck down by Rajasthan High Court, Supreme Court says it is subject to the outcome of the proceedings. This Honorable Court, again on 16 January 2023, well before the appointments that took place on 30th of March 2023, said all further actions by respondents will be subject to further orders of this court. So those appointments are all with qualification.
Let us hear the counsel for the petitioner and Kesri Nandan. Yes, please.
That is Mr. Gopal Shankar Narayan was appearing.
Well, I'll assist Mr. Shankaran who's just joining. I'll also have that compilation that we have submitted. We have produced the prayers in the KC Nandan matter, which may be relevant to address on the fact that whether the petition is maintainable or not maintainable. And also, may kindly have that compilation for a minute.
Mr. Kalra, Mr. Chaudhary is here to represent Kesari Nandan Sahu and another. Let him argue first. Yes. Huh?
We adopt the arguments of the Mr. Shankar.
Shankar Narayanan is not there on
He's
screen.
just joining in 2 minutes, my lords. If my lords would permit, I will assist till the time he joins. In case it's Nandan Sahu's matter.
Who is the petition now maintained?
I have challenged the legality and validity of the MP Rule 2018 as well as the notification issued by the NCT, including the advertisement issued by the DAPA.
Let's take out your petition. Yes.
My lords, for the ease of this court, the KC Nandan Sahu prayers are already there in that convenience. If that is what my lords are looking, that's only to assist my lords. And my colleague is here already anyway.
What is your prayer in this?
Yes, my
My
lord.
apologies. I had to
My
change
lords, the
systems
prayers
and
in
network.
Kesari Nandan Sahu, my lords will find at page number 2 of that small compilation itself, where the petition and the prayers are set out in second column.
Mr. Arora, let Mr. Thakur address.
Yes, yes, absolutely. Let Mr. Shankar Narayan take over. We were only assisting, my lords, in the interactive.
My lords, if you can just see the prayer in our writ petition. We have set it out in our compilation also at page 2. Do my lords have that? Do your lords have the compilation we had submitted?
Prayer clause in front of me. Yes.
Provide the compilation.
No, I have the petition in front of me. Prayer clause is there in front of me.
Yeah,
Yes.
prayer clause. So if I can just read that. The first prayer concerns the NCT notification. Now that has been decided by the Supreme Court. Finally, they have struck down the notification which had provided for B.Ed to be a qualification. The second, and this notification was the one that provided for the B.Ed candidates to have the eligibility. The second prayer, that the Honorable Court may kindly be pleased to issue a writ not to treat B.Ed candidates as eligible for the post of so-and-so without passing NCT prescribed bridge course. If I may pause here for a minute. The minute they have treated B.Ed candidates, they have appointed B.Ed candidates, and those B.Ed candidates get a preference over me, I am affected even if I am appointed. The simple fact of my appointment doesn't take the wind out of my sails completely, as my friend is choosing to argue. I have an issue with ineligible candidates coming in who will at later stages make claims regarding any avenues of progression that I would have, which is why it's very much maintainable by me saying that you do not have a legal qualification to be here in the same cohort as me. That is my argument.
We are raising an issue which is not here before us, and the issue is of seniority among
I'm sorry. It's a question of eligibility, Manoj. It's a question of eligibility. I'm saying if the entirety of the NCT, I'm sorry, I shouldn't have interrupted. I'm sorry.
You are raising the issue of inter-se seniority between the DLED appointees and the B.Ed appointees whose appointment has now been saved by the Supreme Court. Now that issue was never there. So
it wasn't, and I'm not raising that. I'm not raising that. Let me just clarify what I am raising. I am raising the fact that there's no question of inter-se seniority if the other person doesn't exist. The other person who is a B.Ed candidate, the Supreme Court has made it very clear that since petitions were filed and interim orders were passed, which is the virtue of which you are allowed to continue, you will not have the protection. So the B.Ed candidates go out completely. My issue is with the B.Ed candidates remaining in the room. That's my problem. They cannot be eligible at all. And that is why I was here in the Supreme Court as well, arguing this very issue before the Supreme Court. There was no objection taken to my locus standi here.
candidates,
I'm very surprised that somebody's taking it now in the High Court.
despite having a BEd,
Yes.
who have been appointed and saved by the Supreme Court, the appointments are valid now. Subject to satisfying those conditions in the Supreme Court.
Correct, correct. So if they have not if they were not appointed prior to the judgment, appointed on the 10th of August, in fact, the day before the Supreme Court judgment, the notifications have been issued by the Madhya Pradesh government intending to appoint them, but not actually appointing them. That's a very important distinction to be borne in mind. There are two swaths of appointments that have taken place in Madhya Pradesh. One on an earlier date, and the second the day before the judgment, which is a remarkable coincidence. I'm sorry, between 30th March and 15th April, there were appointments carried out. But then on 10th August, they claimed that there were some more notifications issued, but not appointments made. Appointments are all made after the judgment. So they would not be saved either. As far as the interim orders are concerned, the interim orders are applied across the board to everybody. As a result of which, no BEd candidate in Madhya Pradesh can make a claim. Right. I may point out that when the first interim order was passed, your lordships took note of the Rajasthan High Court judgment, the judgment that was sustained by the Supreme Court on the main matter. That was taken note of. I may also tell you that after your first interim order, these very interveners came to the Supreme Court, filed an application for intervention as well in the main matter. And yet the judgment came. So it binds them all down. I'm grateful.
Yes, Mr. Kapil.
But the interim order dated 16 January 20.
Yes. Bola.
16 January.
Five 995 is 16 January. Yes.
Also, the interim order, all the further action by the respondent will be subject to other law.
Yes.
Regarding the one set of petition, KC Nandan and
बोला एक तेज का जो ठाकुर साहब बता रहे हैं आपको इसमें ऑर्डर उसको फिर क्लियर किया था 28/8 को भी देखना होगा इंटरव्यू ऑर्डर उसी में
नहीं बनता है उसको थोड़ा नहीं हुआ है
28/8 को फिर क्लैरिफाई किया कि अपॉइंटमेंट सब्जेक्ट टू आउटकम रहे इनिशियल में दैट वाज नॉट द डायरेक्शन
Hearing in length without this order is also
repeated directions are not passed by the honorable court. It is only when by the initial order which was passed on 16th of January.
If you see the 16-1 order, it's of a very generic nature. It covers everything. Further action by the respondents will be subject. Further action means recruitment plus appointment.
Your lordship may kindly see the subsequent interim order. On 28th of August 23, in the same writ petition.
Yes, yes.
Was the intent of the honorable court that the appointment shall be disturbed, but the subsequent interim order can be passed by the court. But then, my lord, specifically the court was kind enough to direct that no further appointment shall be made. And this, that the order was passed on 28th of August 2023.
Yes.
Now, the electorate cannot skip this order and refer the initial order in which this order the court never directed that the appointment order shall be kept subject to final order.
Yes.
So, my lord, both the interim orders are required to be seen.
Yes.
I'd be surprised, my lord, that my learned friend will say that repeated interim orders are required to be passed by the honorable court. My lord, I have not seen. In my life, my lord, that repeated interim directions of similar same nature is passed. Once the interim protection is granted,
Yes.
end of the matter.
Yes.
It is there, but because there was no intention of the honorable court to keep the appointments subject to final outcome, and therefore subsequently on 28th of August 2023, my lord has specifically directed to keep all the appointments subject to final outcome. This is my
That we have noted. Yes.
Now, my lord, please. Or if you are paying.
Have you completed? May I please talk about Kesari Nandan only. Your counsel in all petitions. So what remains in Kesari Nandan now? The relief that you have sought has been granted. What other relief you have?
I'm not given the appointment. Sir.
Then what are you claiming? Yes.
I have challenged only the validity of the rule of the state government published in July 28.
Which rule? Where is that? Where is that challenge in the prayer form?
Para 7.5, Manoj, at page 30 is the challenge to the rule. Para 7.5, page 30.
Schedule 3, Madhya Pradesh School Education Conditions. With advertisement data. 61/2022 contended and 51. Only to the extent of Madhya Pradesh primary teachers eligibility test 2023. Restraining the B.Ed degree holders candidate for appointment on the post of primary teacher, school teacher, and to give appointment only to those who are DLED diploma holders candidate.
This is already granted to you by the Supreme Court. Granted ho gaya na ye to. They have said that DLED is the prescribed qualifications. And so far as B.Ed appointees are concerned, they have passed certain orders protecting some appointments, not protecting some, subject to certain conditions. Are we going to sit over the Supreme Court? Then Supreme Court has decided that case. Supreme Court has upheld the Rajasthan High Court order. Rajasthan High Court quashed the notifications. And this order of the Supreme Court also covers all other cases mentioned, I think, in the last paragraph.
All other states also. It covers all states.
Here, that directions contained in the order shall not be confined to the applicant, state only, and shall cover all cases which may be pending in different judicial fora in any state or union territory on the same point of view. What remains now? Anything else? Who? No, there are only two petitioners there in this petition. Which petition? In which case?
Point one, Will Kumar Dwivedi, they have not appointed. And Tarun Agarwal, there is, and petitioner, they are also not appointed.
So this Vipin Kumar Dwivedi, what diploma holder or?
Diploma.
A diploma holder.
Manish Sen, they also not got appointment. On the petitioner of diploma about the unit.
There also there are two petitions. Same petition.
Yes.
The prayer are same or different?
They are
Same. Copy paste.
My lords, it will be fortunate if they are copy paste because then they are wide in nature and they are then in rem. So even one petition will cover the relief for everyone else who's similarly situated.
All the parties were directed to act in strict compliance of the law. It's a past matters of office, there is, that will serve the purpose of the petition. If you have option, one grants appliance is ordered.
That is exactly what I had said in the beginning.
Yes,
That-
yes, but there is something about that direction.
So let the state government,
Directions of.
let the state government implement. If there's any folly in the implementation
Yes.
process, they'll come back to it.
Well, that's there, yes. Yes.
My lords, with that, I think it's a writing on the wall. If my lords have heard the argument of the learned AG, my lords, then it's a writing on the wall. My lords, the learned AG has in no uncertain terms suggested a particular position and which I guess will be the position of the state. I would request my lords to my
Let
lords,
Mr. Dilli also argue.
Yes.
Yes, Mr. Dilli.
Lords, may please see, Lords, may notice few dates. So this advertisement is issued on 6/1/2020. Why I am drawing the attention of the Lordship, I relate it to the order passed by the Supreme Court.
No, Mr. Gilia, you are appearing for?
Or I am appearing in K.C. Nandan as well as this Vipin Kumar, we earlier we had filed intervention application. Our applications are allowed, we are included as respondent.
You are BID appointees.
No, yeah.
Yes.
Now, my lords, may kindly notice, the advertisement is issued on 6/1/2020.
Yes.
The examination is held on 5/3/2020. 5/3/2020.
After more than 2 years.
Yes.
This is written exam.
But this was delayed due to COVID and all of the certain examination.
All right.
Then, my lords, this petition was filed on 13/6/2022. K.C. Nandan's petition
13/6.
2022. And it was filed by these petitioners who had already participated in the process of selection. They went by the conditions of the advertisement, participated in the process, and thereafter they filed this petition on 13/6/2022. The interim order was passed on 7/7/2022.
Yes.
During pendency of the petition, both the petitioners got selected and appointed.
When was that?
Now their appointment orders are fixed.
The appointment orders.
Both are appointed. Well, we had supplied the copies of their appointments. I'll just give the dates. 4/4/23.
Both. Same date.
Yes. They both were appointed.
Yes.
Now, can we see the relief clause words, which Manoj have just seen, relief clause in the report? Because it has been said that their grievance still subsists. Now, how it subsists, Manoj, please explain the relief. 7.1 is Manoj that relief they have already got. As per Manoj, 7.1 is concerned. That NCT regulations now that has already been declared well. Now can we see 7.2? That the honorable court may kindly be pleased to issue an appropriate writ order or direction not to choose BEd candidates eligible for the post of primary level teacher in schools under RT Act 2009 without passing NCT prescribed this course before appearing in TET examination. This relief has already been granted and the BEd candidates have been held ineligible prospectively. The appointment management kindly noted that the appointments of the BEd candidates who have already been appointed subject to the condition imposed by the Supreme Court, their appointments have been protected. And it is held to be ineligible only prospective. Now, relief 3. That the Honorable Court may kindly please to grant liberty to the state government to treat only VSTC candidates as eligible for appointment on the post of primary teacher on account of availability of adequate number of sustained teacher, or to give them preference and weightage in the selection process of primary level teachers above said B.Ed teachers who are not possessing adequate training and qualification for working as primary teacher to teach students in class 1-2. This related also becomes instructors with their appointment. Now, next, to this Honorable Court may kindly be pleased to the extent that the same relief to the present petitioner as has been granted by Honorable Rajasthan, well, this has also become instructive. That the Rajasthan High Court has declared the NCT regulation as illegal.
Yes.
And then to set aside the impugn column 5, Malaks have already addressed to that, and this has become infructuous because in view of the declaration by the Honorable Apex. Now, as far as this petition is concerned, nothing survives in this petition after appointment of these petitions. And this we are not saying today. If Malak should recollect, we have been saying it right from the beginning that after that appointment, this petition has been rendered. Now Malak should kindly come to the order passed by the Honorable. Malak, Mr. Patwalia has already read this paragraph, but I will just once again I reiterate that because there is a very fine aspect involved in this. Can you see page 7? Every word has a meaning. And as the law says that there is nothing which can be termed as superfluous. Please have a look on page 7. As it appears that a large number of candidates with B.Ed degree have already been appointed on the basis of eligibility criteria specified by the Educational Authority, we do not think it to be equitable to affect their removal. We accordingly hold that the judgment delivered by this bench on 11 August 2023 shall have prospective operation. But prospective operation of this judgment, now here onwards, please see, but prospective operation of this judgment shall be only for those candidates who are appointed without any qualification or conditions imposed by any court of law, to the effect that their appointment would be subject to final outcome of the case, which might have been instituted by them. It's institution by them. And this word has got a meaning. Why? Because it is said, like, please see, number of cases when the petitioner files a petition before your lordship, he makes a prayer for interim relief. Sometimes my lords permit them, grant them that interim relief, but my lords also specify that their relief, which has been granted as an interim measure, will remain subject to outcome of the writ petition. And it's not only that my lords go to the extent of saying that no equitable flow in their favor out of that interim order. The situation is like this, that if a B.Ed candidate had gone to the court saying that we have been selected, yet the government is not giving us appointment, and then the court would have said that grant them appointment, court would have directed the state government to grant them appointment, but that appointment will remain subject to outcome of the writ. The situation is like this here, that the Supreme Court says that the proceeding instituted by them. Now, here is a situation where I pointed out to your lordship. Advertisement is issued on 6/1/2020. Writ petition is filed on 13/6/2020 after participating in the process. The interim order is passed at our back. We are not participating in the proceeding at the district. So there is a difference now that if these proceedings were instituted by these B.Ed candidates, and if this interim order was passed, at their instance, it would have a different connotation. Then, the interim order passed in a petition which is filed at their back, and Supreme Court has not viewed. It could have been left like this, that if any what was the necessity of adding this word, that they might have been instituted by them. It could have been said only that the final outcome of the cases which have been instituted. But the Supreme Court has used that word, the word them. Therefore, my submission is this one, that makes a difference. That the appointments were, firstly, we say that this Kesri Nandan's case, one of this interim order was passed in the Kesri Nandan's case, which has already been rendered infraction. Now, second aspect is this, that even if it is assumed that this interim order survives, even then, now this interim order is not passed by, on a petition filed by the candidate of B.Ed category, my lord. This is the petition filed by the DLED candidates. Now, the learned advocate general has already pointed out to your lordship the order passed by the Calcutta High Court. And my lord, the Calcutta High Court has very categorically said that because my lord, there is nothing to adjudicate now. As far as this aspect is concerned, my lord, Supreme Court has said that this is the order. And now my lord, this order has to be implemented and everybody has to implement the order as per the, my lord, the letter and spirit as per the direction passed by the Supreme. Therefore, my submission is this, my lord, that
So the petitioners in these, in the first case and the second case, petitioners are diploma holders. And in the third and fourth and all,
petitioners in the first case, also they are also the DLED.
they are diploma holders.
Yes, they
Yeah,
are
they're diploma holders.
diploma. Yes.
And what about third and the up till?
Well, they all are diploma.
All are
All
diploma.
are diploma. That is what I say. That
So-
no
All are diploma holders, all of
There
them.
would be no cause for the B.Ed candidates to come to court, my lords. It's obviously only the diploma candidates will come to court. This is such a twisted interpretation. If you see that, if the B.Ed candidate had come to court, he will not get a protection. That is the suggestion here. Because otherwise everybody else gets
In two
protected, but
courts,
a
the
B.Ed
B.Ed
candidate who
candidates
comes to
went.
court will not get a protection.
B.Ed candidates went to
Sir.
court in Rajasthan and B.Ed candidates went to the Supreme Court in Chhattisgarh.
This was a Madhya Pradesh application in the Supreme
Was
Court.
for the simple reason that the Rajasthan government did not accept government's 2018 notification. Because Rajasthan government did not include the B.Ed in the exam.
Please let Mr. Gildea complete.
Yes.
Yes.
my submission is this. That the order passed by the Supreme Court has to be read in that respect. And with that, my lord,
So according to you, all these protection is only to B.Ed appointees.
this protection is
To B.Ed appointees.
to be appointed now because there are now the conditions Supreme Court has imposed, firstly that the judgment applies prospectively. So the appointments made, they are already protected. The only matter was that there should not be any order passed by the court subject to outcome in the proceeding filed by them. There is no proceeding filed by them. Otherwise, Malok, there was candidacy, this could have been left by without adding this term then.
So all these conditions imposed relate to people who are B.Ed and were appointed and then approached the court.
Yes.
Did not.
In some states, not B.Ed.
These conditions apply.
That would never happen.
In some states, the rules did not permit B.Ed
This
to
is only
complete.
about
For
Madhya
example,
Pradesh.
Rajasthan. Rajasthan rules made B.Ed ineligible.
Rules permitted B.Ed.
Here, MP rules permitted.
Yes.
Rajasthan rules did not permit. So Rajasthan, the B.Ed candidates went to court and got an interim
What I
order
said.
saying that you can participate in the selection process.
This entire clause is
In-
an exception to the
In
protection.
Chhattisgarh,
It's an
kindly
exception to the
don't interject,
protection and
please.
must be
In
read as such.
Don't interject. In Chhattisgarh,
You also
the
interjecting.
court held that B.Eds are not
an
eligible.
exception to the
So the
protection,
B.Ed
my lord,
candidates
and it
went to
must
the
be read as
Supreme
that.
Court and got an
Otherwise,
interim
the
order.
B.Ed candidates would have the protection, provided, however, that there was no interim order. Otherwise, they have the protection regardless of whether they have
not
a
in two
petition or an
states,
interim order or
in
anything.
two states,
There's
the
no
B.Ed
exception at all.
candidates had gone to court.
The entire law
In
is struck down and they get all
and
the protection.
Chhattisgarh.
There was no Malok disqualification as far as in the rules
Lords,
Yes.
we can't
Mr.
lose
Patwari
sight
must be
of
fair
the
to the court
fact,
about what he argued in Supreme Court.
my lords, we can't lose sight of the fact that Rajasthan High Court had already struck down that qualification. And the advertisements came after that.
Okay.
Let
Now-
Mr. Gildea complete, please.
That aspect is concerned, we need not to go into that now. The Supreme Court has now what has said now, it's not immaterial now. The Supreme Court said that our judgment applies prospectively, meaning thereby of the decision of the Supreme Court, the B.Ed candidates are not to be treated as eligible, and their appointments have been protected. And the rules of Madhya Pradesh, now they permitted the B.Ed candidate, as the rule existed at the time of issue of advertisement, the rules permitted the B.Ed candidates.
No, rules permitted the B.Ed candidates also to be eligible.
Yes,
Also,
yes, also.
besides diploma.
Correct. Diploma in B.Ed. And also, please see, it has been always been said that if these seats are given to B.Ed candidates, what will happen to B.Ed candidates, because they can only go for the primary teacher's appointment and they have no other avenue left open. This is absolutely incorrect. Please go through the rule. Rules, my lord, they permit the B.Ed candidates not only to participate for primary teacher, but they are also eligible for middle teacher. This has all, my lord, this would not be pointed
The
out.
relevant rules are on record? Not. P1. In which case?
The advertisement is clear.
For this 2018 statutory rules, my lord, it could be, my lord, we can supply.
No, in which case?
These rules are in Kesri Nandan's case,
First case.
first case.
Yes.
These rules permit now that B.Ed.
Which is the relevant column in that schedule?
Rules are.
This is
Column 5 of schedule 3. That's what our prayer was for.
P1 is Vipin Kumar, 595. My lord, P1 in both the cases. P1 in both the cases.
Please see room, page 70.
Column 5 schedule.
71 or 38?
No, it's not 70.
38.
Or it is rules are in Hindi,
38. Page 38.
page 30, page 38. And in these rules, the
What the nature of
कम से कम 50% अंकों के साथ हायर सेकेंडरी अथवा इसके संपर्क
Maharashtra, please see.
अथवा 50%.
Athwa is or.
अथवा 50%.
Athwa is or.
Athwa, yes. Schedule 3, Maharashtra, looking schedule 3. Yes, माध्यमिक शिक्षा.
प्राथमिक शिक्षा का है ना ये?
प्राथमिक शिक्षा के लिए प्राथमिक शिक्षा, yes. What I was trying to point out is that DLED candidate is not only eligible for प्राथमिक शिक्षा, that is the primary teacher, but they are also eligible for the middle teacher, माध्यमिक शिक्षा.
No, we are not concerned with middle mathematics.
It has been said, Manoj, it has been argued that if the DLED candidates are deprived of their opportunity of appointment as a primary teacher, they have no other avenue open to them. Because they cannot apply for Madhyamik Shiksha and Uच्च Madhyamik Shiksha. That is incorrect.
No, we are not here to adjudicate.
Yes, that is.
Everything has been done by the Supreme Court.
Yes.
We can't enter into that field of adjudication.
Now, Prathmik Shiksha की qualification, Manoj, please have a look. Prathmik Shiksha. Now, it is Manoj, कम से कम 50% के साथ हायर सेकेंडरी का क्वालिफिकेशन के प्रारंभिक शिक्षा में 2 वर्ष का डिप्लोमा के साथ अथवा 50% अंकों के साथ स्नातक अथवा शिक्षा स्नातक B.Ed. Now it is B.Ed. शिक्षा स्नातक दी बैचलर इन एजुकेशन B.Ed. जिसने राष्ट्रीय अध्यापक शिक्षा परिषद मान्यता प्राप्त संस्था से स्नातक की उपाधि प्राप्त की है। उस पर कक्षा 1 से 5 तक पढ़ाने के लिए अध्यापक के रूप में नियुक्ति हेतु विचार किया जाएगा। क्योंकि अध्यापक के रूप में एक व्यक्ति को राष्ट्रीय शिक्षक के रूप में नियुक्ति होने के 2 वर्ष के भीतर राष्ट्रीय अध्यापक एवं शिक्षा परिषद द्वारा मान्यता प्राप्त प्राथमिक शिक्षा में 6 महीने का एक सेतु पाठ्यक्रम आवश्यक रूप से पूरा करना होगा अथवा कम से कम 45% अंकों के साथ हायर सेकेंडरी अथवा इसके समकक्ष अथवा राष्ट्रीय अध्यापक शिक्षा परिषद मान्यता मानक एवं क्रियाविधि विनियमन 2000 के अंतर्गत प्राथमिक शिक्षक शास्त्र में 2 वर्ष का डिप्लोमा अथवा कम से कम 50% अंकों के साथ हायर सेकेंडरी अथवा इसके समकक्ष का प्रारंभिक शिक्षा शास्त्र में 4 वर्षीय स्नातक उपाधि B.Ed. अथवा कम से कम 50% अंकों के साथ हायर सेकेंडरी और इसके समकक्ष शिक्षा स्नातक विशेष शिक्षा में 2 वर्षीय डिप्लोमा अथवा स्नातक उपाधि प्रारंभिक शिक्षा में 2 वर्ष डिप्लोमा अथवा इसके समकक्ष आरक्षित वर्गों जैसे अनुसूचित जाति जनजाति अन्य पिछड़ा वर्गों तथा निःशक्त व्यक्तियों के अभ्यर्थियों को इनको में 5% and each should there.
So this
So
B.Ed was added
B.Ed is also there.
as one of the alternative eligibility
Yes.
criteria. And this was struck down. This has been struck.
Now it has been.
I'm sorry to interrupt, Malad. That has not been struck down. Your lordships will have to strike it down. It's the Madhya Pradesh rules. Nobody else has struck it down. In terms of Supreme Court's finding, your lordships will have to strike it down formally. That's prayer 7.5 of our writ petition. Nobody has struck it down so far. Your lordships will have to strike it down.
And what happened in Rajasthan?
In Rajasthan, it was the NCT notification, Malad.
Rajasthan,
The underlying one, that was struck down.
Rajasthan, the rules did not permit B.Ed to.
The rules did not
compete.
permit, so there was no challenge to the rules.
Rajasthan
The challenge
rules
was
did
to
not
the
permit
NCT
B.Ed.
notification. And the court
Rajasthan
in fact
rules did
held
not
over there
permit.
that despite the Rajasthan rules not having been amended in accordance with NCTE, you had deprived B.Ed candidates from taking part. So there the Rajasthan High Court said you should have allowed B.Ed candidates to take part until the stage at which the NCTE notification was formally struck down. But
So
here the fact
Rajasthan,
that
what happened, my lord, the Rajasthan rules did not allow them. The NCT notification said they are eligible. The advertisement did not allow B.Ed, and therefore the B.Ed people went to the High Court saying we should be allowed to
the
compete.
light of quashing of this NCT notification,
Yes,
rule also has to be struck down.
correct,
Yes, it
correct,
has
correct.
to.
Now,
Yes.
from now the rule, now once the notification goes, the rule also cannot survive because the court says B.Ed are not eligible.
Since the mother body of teaching education.
Correct. So therefore the question arises, what happens to people who were eligible under the state rules and who have been appointed? That's the issue. And there our interpretation
that's
is
covered by the Supreme Court's order.
if the B.Ed people had not gone and secured orders, their appointments would be saved.
That doesn't apply to Rajasthan.
I don't think there is a
that
rocket.
doesn't
My
apply to
lords,
Madhya Pradesh.
frankly, the Supreme Court having struck it down and having held that B.Ed is not an eligible qualification for the purpose of appointment to primary, the question of anything further does not arise. Because-
This B.Ed.
Yes, my lord, so the rule
Yes,
as it
it's only
prescribes for, yes,
MP is
it's
the
only,
No,
Only
many states
diploma.
not. In many states,
Only
all
diploma.
states, almost all states, except Rajasthan and Punjab, in all states B.Ed are eligible. Only 2 states they were not eligible.
lords, today the position is this, that they are not eligible. Let us
Yes.
not forget that part. It has been found that their qualification is not eligible, they have to go. The only question is whether their appointments, they suffered a kind of a, my lords, an objection to their appointments, or there was an order that made their appointment subject to the outcome.
On which point?
Not on the point of this writ petition.
Because they had participated.
Yes, there are 3 aspects of it. Firstly, no PIA, my lord, in the matter of service. Number 2, those who have not been arrayed as parties, against them you cannot get any relief. And third, very important is that my lord has been putting right from the beginning question, which is the date of the advertisement, which is the date of filing of the petition. All of them have participated in the selection process. And at the end, my lord, when they said that exams we could fare well, then they filed this petition. Similar letter 3, 2010, volume 10, SCC page 707. That is J. Srivastava versus State of Madhya Pradesh. Come down, Lord. To para 15 of the order.
Yes.
My lord has come to para 15.
Yes.
Very with my lord's information.
Yes.
In para 14 of the pehle. However, the main argument by the appellants against entertaining WPC and so is on the ground that a PIL in service matter is not maintainable. This court is of the opinion that there is considerable merit in that contention. It is common ground that dispute in this case is an over-selection and appointment, which is a service matter. In Duryodhan Sahu, Doctor versus Jitendra Kumar Mishra, that is 2010-10 SCC 707. A three-judge bench of this decision held that a PIL is not maintainable in service matters. This court, speaking through Srinivasan J, explained the purpose of administrative tribunals created under Article 323A in the background of extraordinary jurisdiction of the High Court under Article 227, 226. This court held if public interest litigants at the instance of strangers are allowed to be entertained by the administrative tribunal, the very object of speedy disposal of service matters would get defeated. Same reasoning applies here as as public interest litigation has been filed when the entire dispute relates to selection and appointment, just like my case. Para 16. In B. Srinivas Reddy, that is 2006, volume 11, SCC 731. And this court held that in service matter, only the non-appointees can assail the legality of the appointment procedure. That is the end of the matter, Lord, in most of the cases. Para 17. This view was very strongly expressed by this court in Dattaraj Nathuji Paware versus State of Maharashtra, that is 2005, volume 1, SCC 590, by pointing that despite the decision in Duryodhan Sahu, PILs in service matters continue unabated. This court opined that the High Court should throw out such petitions in view of the decision in Duryodhan Sahu. The same principles have been reiterated in Ashok Kumar Pandey in a recent decision of this court delivered on peace. Thus, in Banchlal, it has been held that except in a case of co-warrant of PAL in a service matter is not maintainable. Now, para 20. The next point urged by the appellants that they have never been included in the two petitions, even as the orders passed by the High Court had a direct effect on their livelihood, also goes to the root of the matter as it violates the principle of order. Here also, Lord, I spoke to my Lord only in two petitions. Look, please hear me. In one case, I'm respondent. In other case, I'm intervener. Now, para 21. This court in Prabodh Verma versus State of UP held the High Court ought not to decide the writ petition under Article 226 of the Constitution without the person who would be vitally affected by its judgment before it as the respondents. They have never bothered to make any of us as parties block. So many of them selected. Similarly, this court in Dhamara, all these judgments are referred. And para 23 May, there is another important judgment. Para 23 B. Ramajini versus State of Andhra Pradesh, where selection of certain teachers was challenged without implementing them. This court held selection process has commenced long back, as early as in 1998, and it had been completed. The persons selected were appointed pursuant to the selections made and had been performing their duties. However, the selected candidates had not been included as parties to the proceedings, either in the individual capacity or in the representative capacity. In that view of the matter, the High Court ought not to have examined any of the questions raised before it in the proceedings initiated before it. To that extent, the Supreme Court has gone. The writ petitions filed by the respondents concerned ought to have been dismissed, which are more or less in the nature of a public interest litigation. So, Lord, this is the judgment of Girjesh Srivastava. I have requested my Lord's leader also to show me another judgment. That is called Lord Saroj Kumari, 2017, volume 9, SCC page 478. Because Lord,
On the same point.
no, it is on the point that they were very happy appearing in the exam, my Lord. Aram se exam hai. Lord, the rules were published, Lord, way back in 612. My Lord, everyone has given the chronology to my Lord. I have also given the chronology in my return. उसमें मैंने तारीखें बताई हैं. हाँ, जी हाँ, ये रूल है 28/6/2018 को एक रूल हुआ मध्य प्रदेश का रूल 1/7/2018 हुआ. Everyone is very happy. 6/1/2020 primary school teacher eligibility test advertised, and everyone participated peacefully on 5/3/22. After having participated, my learning friend Mr. Vidya said that this WP KC Nandan was filed on 13/6. No, Lord, it was filed on 16/6. On 16/6/2020. कोई बात नहीं, एकदम इनका फर्क. So 5/3/2022 को they participated in the eligibility test, knowing fully well that along with me these B.Ed candidates are also appearing. I'm representing all those B.Ed candidates, Lord, who have been selected, appointed, they are working on the basis of this advertisement, and these candidates were very happy. So, Lord, what Saroj Kumari says, Saroj Kumari is absolutely clear on this topic, not para 4. The main ground urged on behalf of the appellant is that respondent number 1, having taken part in the selection process, could not be permitted to challenge after she was unsuccessful. Now, Lord, para 5, we only one sentence that makes the position clear. Para 5 में, in G. Sarma versus University of Lucknow, the petitioner, after appearing in the interview for the post of professor and having been not selected, pleaded that experts were biased. It was not made. Now, Lord, para 8 is important. Ramesh Chandra Shah has been quoted with approval in Saroj Kumari's case. Ramesh Chandra Shah. That is also 2013, volume 11, SCC, page 309. Saroj Kumari का case.
Yes.
इसको कोर किया है, sir. I would like to read with my lord's kind permission. Para 8, no?
Yes.
Para 8 में para 24 is quoted. In view of the propositions laid down in the above noted judgment, it must be held that by having taken part in the process of selection with full knowledge that the recruitment was being made under the general rules, the respondents had waived their right to question the advertisement or methodology adopted by the board for making selection, and the single judge and the division bench of the High Court committed grave error by entertaining the grievance made by the respondents. Not
Mr. Luthra, if I rightly remember, maybe I'm wrong, that on this point, there was some difference of opinion in the Supreme Court itself, and it was referred to a larger bench. Some recent view has come or not?
No, not that. It might have been distinguished. I don't think it is over because
When can a person who participated can still challenge or not challenge? To what extent he can
you have
challenge?
to vent your grievance before commencement of the election. You have to, because when I was appearing for the radio every day, I used to use it because people used to come after the selection process. Now, Lord, the most important thing is that, Lord, all these questions regarding whether B.Ed, I am representing those B.Ed candidates who have been selected, appointed. They are working. Now, Lord, as far as KC Nandan and Rohit Kumar, the case in the petition is concerned, it goes because of not this judgment which I said, Lord, Srivastava. Because, and as far as the other petition is concerned, even in that law, they have not, my Lord, bothered to erase any of the selected candidates. Everyone knew that the selection and the appointment had been done. Lord, way back, appointments of the interveners was issued on 30/3/2023. उसके बाद सब petition पेश की. Then why not make any of them the parties? No, I will not make them parties, but they are. Now, Lord, my Lord,
No opponents are made when the petition is filed.
he made one point, I want to reiterate that. That is it, that Lord, that there may be many cases in which B.Ed candidates might have lost in high courts. I want to make that. Many candidates, not B.Ed candidates, might have lost in the High Court. Then they went to Supreme Court. Supreme Court would say that no, your appointment is subject to the final decision of this SLP. So in a petition filed by them, if their appointments are subject to the final decision, that is what the Supreme Court judgment says, Lord. Everywhere they say their appointment would be subject to final outcome of the case, which might have been instituted by them.
Well,
We have not instituted any case. State of Madhya Pradesh was very happy to entertain B.Ed candidates. We participated in the selection process. strict interpretation, exact interpretation of the.
So that Mr. Gildial has submitted.
Yes, sir. I adopt his argument and the argument from my learned friend, Mr.
May I respond to these arguments, Suraj, for a minute?
You want to say something?
Yes, I just want to respond to two things. One,
You are appearing for
on the fact that we didn't,
One,
6350.
not all these,
आप तो सुनेंगे फिर मेरे दो
all these arguments,
Lordship,
not one, all these arguments, one by all others, Lord, except Vipin Kumar Dwivedi, are not worth considering. That is my most.
बट मेरा कंसर्न सिर्फ इतना है ऑनरेबल सुप्रीम कोर्ट ने साफ कहा है कि दो सेट बनेगा। पहला सेट उनका जो किसी भी प्रोटेक्शन को लेकर के वो अपॉइंट नहीं हुए, वो है मध्य प्रदेश लॉ। बहुत सारे ऐसे स्टेट जिन्होंने बीएड को अपने नोटिफिकेशन में लिया ही नहीं, तो उन्होंने साफ तौर पर ये कहा है कि जो प्रोटेक्शन के साथ अपॉइंटीज हुए उनको निकाल दिया जाए। मध्य प्रदेश में 11/10/2023 के पहले एक भी बीएड अपॉइंटीज जो है हाई कोर्ट नहीं आया, किसी भी कोर्ट नहीं गया, ना ही किसी कोर्ट ने उसको अपने ग्रांट करके के द्वारा उसको अपॉइंट किया। लॉर्डशिप यह स्टेट, तो हमारा ये कंसर्न यहाँ पर लॉर्डशिप की हमें ना तो केसी नंदा से ना किसी चीज इनकी जो है, हमें तो माननीय सुप्रीम कोर्ट ने साफ तौर पर सेट 1 में रखा है और मध्य प्रदेश सेट 1 कर रखा है।
Manoj, can I just respond to what my friends had said?
Yes.
Number one, as far as not making them parties, when we filed our petitions, no appointments had taken place. So there was no question of making anybody parties when we made our, when we filed our petitions. Second, all those petitions had interim orders which made it clear that it was subject to the outcome. So we presume that the state, if they are going to make appointments, are going to be informing the people they're appointing that it is subject to the outcome of court proceedings, to the which the state is very much a party at that point of time. Point number 3, repeatedly they have drawn attention to these words at the top of page 8 of the Supreme Court order. Let me just read that again so your lordships have the entire context of it, because they've for some reason decided to amputate that sentence. Let me just read fully that entire paragraph from bottom of page 7. As it appears that a large number of candidates with B.Ed degree had already been appointed on the basis of eligibility criteria specified by the educational authorities. So this would necessarily have to include B.Ed as an eligibility criteria for them to be appointed. We do not think it to be equitable to effect their removal. Therefore, this is not considering a Rajasthan scenario at all. We accordingly hold that the judgment delivered by this bench on 11th August shall have prospective operation. But prospective operation, from here the exception starts, where they will not have the protection. But prospective operation of this judgment shall be only for those candidates who were appointed without any qualification or condition imposed by any court of law, to the effect that their appointment would be subject to final outcome of the case, which might have been instituted. These words by them is what they're emphasizing, saying that it could only be if it's filed by the B.Ed candidates. By them, I would interpret to mean by whoever the petitioners are in that particular case, because the rest of the sentence makes sense, which might have been instituted by them, and such candidates were in regular employment without any disqualification and were appointed in pursuance of a notice of advertisement where B.Ed was stipulated to be valid qualification. B.Ed was stipulated to be a valid qualification in Madhya Pradesh, not in Rajasthan. No B.Ed candidate would go to the court when B.Ed qualification is given in his advertisement. He would only go when it's not given. Therefore, it is very clear that this petition, this order provides that B.Ed candidates who had qualifications provided in their advertisement, who had participated and then were made subject to a order of the court, will not have the protection, provided they were appointed prior to 11th August 23. If you're appointed after 11th August 23, there is no protection. That I think even Mr. Patwala will concede. That is the nature of the prospective order.
When were these petitioners appointed?
These petition, now, as far as the
There are two orders,
intervenors
my
are
lord,
concerned,
30th March 23 and 10th August 23.
now 10th August 23 is not an appointment. Your lordship may check that. There's not one single appointment which took place on 10th August. It's a notification listing those who would be appointed. So the appointments themselves took place after 11th August 23.
March 2023.
So they are all before the judgment.
Correct. They have all been appointed.
Some of them are
the
before,
judgment, my lord.
some are after.
They have all been appointed before
Your
the
lordship may
judgment.
ask for the list from the state with the dates of appointment.
The data.
My lords, our unequivocal submission is that every single appointment took place after your lordship's interim order. The minute it took place after your lordship's interim order, they lose the protection.
That's 2022. The result was prepared not very before time and it was declared on 8th of August 2022.
The interim order is 7 July 22, which takes note of the Rajasthan High Court judgment.
KC Nandan is out. We are not considering.
With Vipin Kumar, there was an interim order.
Please, my lords, on the 16th of January 23.
January 23.
16th January 23, much
fact,
before the appointment on
7th
30th.
July 22, 7th July 22 in my case, in Kesri Nandan, your lordships took note of the Rajasthan High Court judgment and specifically said in view of the above,
Right, you give us that within 2-3 days, within this week. Please give us that.
we'll give you a note, my lords, with all that.
Date of appointment. That is all. The
Date
date
of
of
appointment are
My
only two
lords,
dates.
I had pointed
The
page number
appointment orders
16.
are 30th
Page number
March
16 of the
2023
compilation.
and
Page
10th August
16.
2023.
Mr. Patwalia, to make it easy for the court,
And-
it is the state government
just 1 minute,
affidavit.
madam. And the appointment orders are clear. They are not subject to anything. They are categoric orders of appointment. And
So
they are
court's
not on
orders are
petition.
categorical. Court's orders make it subject to.
Yes.
Government can't decide to do what it wants on its own.
My lords, just to assist my lords, please see page number 16. This is a part of affidavit of the state of MP filed before Supreme Court. It starts at page 13 of the compilation and page number 16. There's also one thing out there. While according to them, 11,583 out of which 2,784 being made on that notification on 10th of August 2023, which they state, they clearly say 284 have been made after 11/8. And they write that they had only issued a notification and that the appointments had to be sent later on, which is mentioned there.
All right, so these first two cases, they are diploma holders. What about the remaining? All of them are diploma holders.
My lords, there was no need for the B.Ed to approach the court in Madhya Pradesh because under the existing thing, B.Ed were eligible. So the challenge to that was made by the diploma holders. And my lords, may I just in 2 lines respond to what has been argued? I would respectfully submit that I heard that argument being made on the other side, that whether in person or in representative capacity. Now, in representative capacity, impleadment was filed before Supreme Court on 11th October 2022, where Supreme Court reiterated the same stay of being subject to the orders issued in the petitions in the case. Now, they were aware even at that time, all the B.Ed, and subsequently the B.Ed have filed their impleadments. So, my lords, that argument and showing all the judgments of not being made a party, etc., is actually holds no water for the reason that they have been before my lords, and the courts have held that in any manner a representative capacity is sufficient in these matters.
All right, we are resolving the case and asking the state to file a tabular illustration.
Please, my lords.
Believing that after extensive arguments, the case stands reserved for passing final orders. Next, further, the council, the state is directed to file a tabular illustration mentioning the date of appointment. Date of appointment of whose appointment?
B.Ed.
Appointment of the B.Ed candidates.
B.Ed.
B.Ed.
So date of appointment letter being issued, that would be important. Date of appointment letter being issued, not the notification.
We need some time to file it.
We'll reserve it and wait for yours.
When is that, not that order, get a time.
That we have.
Grateful, Manoj, grateful.
Very, very grateful, my lord, for the hearing. Very
Point
grateful.
five? Locus. Wait, on what point? What is the point?
They did, so far as the player A and B in the repetition are concerned, we find force in the submission of the learned attorney general. But insofar as the player C of the repetition is concerned, it raised an important public issue and involves the interpretation of Article 156 of the Constitution of India. And again, that's why we do not think that we can rely locus to the petitioner for raising that issue. The honorable apex court.
What is Article 156?
156.
What has that got to do with service matter?
Article 21. A. The right to education.
No, you are talking about Article 156.
Government appointment से संबंधित।
उससे इसका
आपको भी भाषा आपने involved है ना? The Article 21A guaranteed the fundamental right to the children, right to education. The eligible candidate who secured the BA degree, they have not qualified to impart the children belong to age 6 to.
No, that 21A, Mr. Council, is children centric.
Yes,
Not
not to do with the teachers at all.
Where is that issue open now?
वो आप दे दीजिए फोटोकॉपी दे दीजिए फोटोकॉपी यस डॉक्यूमेंट हो गया हो यस
Grateful, Manoj.
Obliged, my lords. We are very grateful for very patient.
Very grateful.
Great.
Bill number 39. Is Anurag Goel.
Lordship of matters primarily argued.
39
And in the case, the minister ruled,
39
Lordship 39.